Assalamu alaikum warahmatullahi wabarakatuh, and a good day. So now we are going to continue our chapter 5, Managing Technology and Knowledge for Engineering, Technology and Management subject. As previously we have covered 2 subchapters, now we are going to the third subchapters on this chapter, which is Managing Intellectual Property. So this is the outline of this session. We are going to cover the definition, the protection of IP, the rights of IP in Malaysia, the examples, registering IP in Malaysia, and also the IP cases. So what is intellectual property? Intellectual property refers to creations of the mind, such as inventions. It can be literary and artistic works as well, designs, symbols, names, and images used in commerce. So this is the definition that we get it from the World Intellectual Property Organization. So it can be any invention, including products, machines, whatever it is, including the literacy and artistic works, designs, and symbols, names and images as well. So we're going to see it in detail. IP is protected in law through several protection methods, such as patents, copyright, and trademarks. For example, so we may be familiar with these kind of words, but do we really understand what the difference between them and which one that we can utilize for our organization? So the protection enable people to earn recognition or financial benefit from what they invent or create. So it's like appreciating the owner, the inventor, who the first invented something. So this intellectual property also ensure that the innovation or creation is attributed to the creator or producer, as I said just now, but also secure the ownership of it and benefit commercially as a result. By striking the right balance between the interests of innovators and the wider public interest, the IP system aims to foster an environment in which creativity and innovation can flourish. Intellectual property is found almost everywhere, as we discussed in our 2 previous subjects on knowledge, on technology, and how we can protect. Right, we discussed previously. It is very important for us to protect the knowledge that we have, so other people couldn't simply cheat or use our knowledge, which we already dedicated it for the business purposes. So here is how we secure the knowledge using IP. So it enables people to earn recognition or financial benefit from what they invent or create. Right, so we covered this. So we have 4 legal means to protect organization and individual ideas and right to benefit from those ideas: patents, copyrights, and we have trademarks and trade secrets. Actually, we have more we have more kind of legal means, but this is the main. What is patent? A patent is a property right of an investor that typically granted by a government agency, such as the Intellectual Property Corporation of Malaysia, MyIPO. So the famous one is from US. Of course, it started from US, the United States Patent Organization. But in Malaysia, we have MyIPO. The patent allows the investor exclusive rights to the invention, which could be a design, can be a process, it can be an improvement of existing product, physical inventions such as machines. And technology and software companies often have patent for their designs. For example, the patent for the personal computer was filed in 1980 by Steve Jobs and 3 other colleagues at Apple Incorporation. So basically, it doesn't matter who and when they get or they develop this, I mean, they innovate something, but in order for us to be secure by patent is who first registered. Okay, so it doesn't matter if Steve Jobs is the maybe the it's not the first who uh, developed the personal computer, but because he the first one who filed this and the filing was accepted later on, is patented, so he is the owner now. Okay, so what is the rich man among the rich men for, you see, for how many decades. So this is the example of patent, Nike glasses. So they have their, the patent document. Actually, you can just search this in the Google patent, and then you're going to you're going to have all the patents that available. So they have a detail, dimensions. They have some labeling. So no one can exactly imitate or copy the same design with the same function of the Nike glasses. So it's been patented. So another example, quick change pants. You see, even the pants been patented. Okay, at the United States. So they have their patent number, date of patent, okay, and many more information here. So they have their design. They're going to explain where is the, the patent unique attributes, the numbers, labels. So no one can replicate the same thing. If they did, then they're going to face the legal action. Okay, an example of patent for Smucker's Castle sandwich. So for the food, okay, if we read here is how they fill the jam, the top bread, bottom bread, and the middle, what is that? So they're going to have the explanation for that, but they patented this, right? In 1999, if it's visible for you, and we have the patent number. So, so if your company, your organization, so you innovate something, you have the new technology, or you improve the existing technology. So it's the matter of documenting it and then apply for the patent. So you secure the right, and then later on you can use it for your business purposes. So that's patent. Next, we are going to see on copyright. Okay. So what is copyright? Copyright provides authors and creators of original material the exclusive right to use, to copy or duplicate their material. Authors of books have their works copyrighted, as do musical artists. All the videos, all the songs, the movies, they have their copyright. So why, if you watch or get it illegally, download it from internet and things, so you may be fined for that act. Even in some developed countries, downloading is illegal. I mean, they automatically didn't allow you. You can't proceed to download if it's copyrighted. Yeah, copyright also states that the original creators can grant anyone authorization through a licensing agreement to use the work. So this is also in the previous example, on the previous subchapters, we discussed about the software things, licensing for this specific software like CAD/CAM, CATIA, so SolidWorks or whatever specific softwares that been licensed. So they have their copyright, but we can use it through a licensing agreement. Trademark is a symbol, phrase, or insignia. It's like a tagline, like AirAsia use, everyone can fly. And what KFC use, licking finger good, right? Something like that. This is identifiable and represent a product that legally differentiate it from other product. So it can be a symbol, okay? It can be a phrase. The trademark is exclusively assigned to a company, meaning the company owns the trademark, okay? So that no others may use or copy it. So we have KFC. So you can't have the same KFC design, but you say it's a what? Chiron fried chicken or whatever it is. Okay, but we have this kind of things in the local market, in the night market. But yes, because no one is going and suing them, right? The trademark is often associated with the company's brand. For example, the logo and brand name of Coca-Cola is owned by the Coca-Cola company. And here is some of the examples of this trademark. Okay, so you have your, we know, okay, by it's not mentioning anything, but you know this is Apple, iPhone, Google, Amazon, Microsoft, you know, it's nothing, it's just M, but we know this is McDonald's, you know, this is BMW, you know, is this IKEA, you know, it's just F, but we know this is Facebook. So this is the international brands, and we also have our local brands here, you know, the RB Highcom, Martec, Alam Flora, Verna. So this is the trademarks. We have trade secrets. The trade secret is a company's process or practice. There is not public information, which provides an economic benefit or advantage to the company or holder to of the trade secret. So what's the best example? We discussed about the KFC recipe, right? So it's a company secret, trade secret. Trade secret must be actively protected by the company and typically the result of the company's research and development. Example of trade secret could be design, patent, you see recipe, formula, or proprietary process. Trade secrets are used to create a business model that differentiates the company's offering to its customer by providing competitive advantage. So we discussed this. All of this started with the knowledge and the technology, how you manage that from, and then you have some know-how things, you want to secure it, you know, and then we manage it through the IP. So we go quickly on IP rights in Malaysia. So we have Trademark Act 1976, means that it started, you know, it's from 1976. It's, but it enforced on the 1st September 1983. Okay, so the trademarks is valid for 10 years from date of filing. Okay, so if you want to play a game, identify the big companies when they file the trademark, and then exactly on the due, when it start to invalid, you go and register the same thing on your name. I'm just kidding. Okay, of course, the company should have a plan. Okay, to re-register. If not, then you see the McDonald's been for more than 10 years, right? Of course, and many companies. So how they, so it means that it's not only you securing the things, but how to sustainably to make sure it's preserved. Okay, so you have your plan. So it's 10 years from date of filing. But in this in Malaysia, right? Usually you're going to be consistent with the global. The Patent Act 1983 was enforced in 1986, and the patent is valid for 20 years from date of application. And we have a Copyright Act 1987. Okay, it's effective as December 1st of December 1987. Protection given by law for a term of years to the composer, author, etc. to make copies of their work. So it's basically include literary, artistic, musical, film, sound recordings, and broadcasts, etc. Okay. So why sometimes when there is a live football match between you know, Manchester United and Liverpool, let's say, so you need to pay, okay? And you can't stream through the YouTube, and there's nothing that you can find. But it's of course illegal broadcaster, we call. Nowadays with the Facebook, everyone just doing it, but they have their acts here. And we have Industrial Design Act 1996. It's become enforced in 1st of September 99. So defined to mean the features of shape, configuration, pattern, or ornament applied to an article by an industrial process features. So maybe this is relevant to all of the industrial people, especially if you are working and you are in industry. So you may be familiar with this. And it's valid for 5 years. It's valid for 5 years. And renewable for 2 more periods of 5 years each. Okay. Next is the layout design of integrated circuits, Act 2000, in force from 15 August 2000. It's valid for 10 years. So commercially exploited. So if you registered for this, then it's specific for AC. And you have optical disc, which is effective as 15 September 2000. So although you have your copyright, act, but this is like more specific to optical disc. Provide the licensing and regulation of the manufacturer of optical discs such as VCD, DVD, CD, etc. And quite challenging because nowadays people not really use all of these things, right? Just pen drive, so you don't know. So this is actually to combat the piracy of content in the form of optical disc. So now it's more challenging. You just, people just using the cloud storage, internet. So they may going to have a new acts coming later on to combat again these continuous issues. And the last copyright in Malaysia is the Geographical Indication Act 2000, so in force on 15 August of 2001. So what is this? What is geographical indication? Okay, it's an indication which identifies any goods, whatever it is, okay, as originating in a country or territory or a region or locality where a given quality, reputation, or other characteristic of the goods is essentially attributed to their geographical origin. So product must come from particular geographical territory. So you can, here we see, uses a name linked to the particular geographical nature of the territory. Like Harum Manis, we have a mango special, we have like a premium special mango. Harum Manis from Perlis. So there's an issue, right? People say they started to plant it, Harum Manis in Kedah, in different states. So if they registered under this, okay, so the Harum Manis is only, the name only can be used for the fruits that are planted in Perlis. And Labu Sayong, from Sayong Perak, and you have a Batik Terengganu, Batik Kelantan, pepper, Sarawak pepper. So you can't just say Sarawak pepper, but it's a different pepper. You just put name. So if those are registered, so it's illegal. You can be fined. So this is for the Malaysian context. What's the global from the popular in global level, like Swiss chocolate or Swiss watch, whatever it is, like what else? So you may know, right? Port Marion from UK. Okay, what is that? I couldn't remember. So this is based on the geographical indication. So you can't simply, use the name, but it's not from particular geographical territory. So here we're going to see on registering intellectual property in Malaysia. So basically what I'm going to share here is just general information. It's not a step-by-step information. Okay, basically you can visit this website, okay, the official portal of Intellectual Property Corporation of Malaysia, MyIPO. So you're going to find many useful information. They're going to give the explanation on each categories, what are they, how to apply, the fees. So you can always refer to the portal. Okay, as an example, see here they have the tab on patent. So patent utility innovation, they're going to explain very brief what patent is, and then to understand the patent, okay, so you can go through all the information that they're given here. And then this is if you want to apply. Okay, you can explore applying for a patent or utility innovation, and then managing your patent. Okay, so here is like managing the existing patent, like you want to renew the patent. Okay, so you can search patent, that item that have been patented. Let's say you want to patent a chair, the ergonomic chair. Okay, then you need to check. Okay, if it's been patented, so you miss your opportunity, right? But you need to, you can do some improvement and try to patent it again if it's possible. So applying for the patent, application process and flowchart, and here is the form and the fees, and here is the related patent act. So the same thing goes to the trademarks, to the industrial design here, geographical indication, copyright, and IC layout, and etc. Okay, so I hope you can explore by yourself here. Okay, here is another example for geographical indications. Okay, so understanding. So there is a very useful websites for all of us. Okay, here is if you want to apply, and here if you want to renew or manage the existing geographical indications. Okay, so that's the thing. So we have to share this, you see. So Harumani's name restricted to mangoes grown in Perlis since 2011. My IPO clarifies. So because there is many issues last time. So you see how clever the people in Perlis. We don't know who who register or file for this, but my APO said yes, restricted to mangoes grown in Perlis since 2011. So if you want to do some changes, check when it's going to expire and go and register before they renew. Okay. What else? The issues. Two artists sue MyNews subsidiary for copyright breach. So they use their artworks in their in their convenience store chain, using on the bags, but the design is the artist. So they sue the company or the MyNews. So means that this guy, they are good because they file for copyright for their design. So they have the awareness, so now they're going to get a free income by filing this. And this is for the international or global issues. US Supreme Court rules in favor of Google in copyright dispute with Oracle. Okay, so you can read. I just sharing the information here that you see this happening. People are suing, even in developed countries. People are making money by suing each other. They took insurance for everything, they registered for everything, and then they're just waiting for people to breach. So here, rule in favor of Google in its copyright dispute with Oracle concerning the use of Java application programming interface for Android development. So there are Oracle using Java application interface for Android. What else? Okay. Apple faces 1.4 billion patent lawsuit in China that may block iPhone sales in the country. Okay. So Chinese firm Shanghai Zhizhen, which was recently awarded a local patent. So you have a local patent for a voice assistant similar to Apple Siri, has filed a patent infringement lawsuit against the iPhone maker that, if successful, could prevent Apple from selling its smartphones and other products in China. The second most important. Okay. So sometimes they do strategically, they plan to register and plan to sue. So who want to give you 1.4 billion in one go, right? I think this is the last example of the issues that related to the IP. South Korea threatens iPhone and iPad ban over patent infringement. Okay. So South Korea is threatening to ban a wide collection of Apple's iPhone and iPads over infringement of a key chip patent. So Actually, it's not a full complete set of alphabet. They have their compartment, they have their path they pattern. So here is key chip pattern, but it's waiting for the result. Okay, we don't know. Okay, you can read for the whole story, but again, okay, everything is related to the politics, business, and things. But most important thing is you secure your knowledge, your profits by securing the IPs. So that's all for the subchapter 3 for managing intellectual properties. So thank you very much. So reference and credits to several people and also the organization. So this is the website for my IPO. Okay, so it's actually myipo.gov.my. So you can visit to check. Okay, thank you very much for watching the video. I hope you understand and you got some insights on IPs and things that related to it. So thank you very much.